My name is Nick, and I'm going to be discussing the procedures to get an unlawful detainer, which in California is a procedure to get an eviction, generally brought by the landlord against the landlord's tenant or tenants when they want the tenants out of the premises. So what's an unlawful detainer? Well, in the state of California, when you need your tenants out of your property, you don't just start with self-help. You don't just start right with an eviction. You start with a statutory procedure known as an unlawful detainer, because this gives the tenants an opportunity to provide any defenses, any affirmative defenses, any rebuttable arguments, based on what the landlord is alleging that the tenant did, which requires the grounds for the tenant to be evicted. So that's why you can't just lock the tenant out. It's due process. You need to give the tenant an opportunity to be heard and file and answer a response to your allegations as a landlord. And so instead of just starting with the eviction, you start with the procedure known as the unlawful detainer. And only if you are successful, and you'll know because you'll get a writ of possession, you'll get a judgment in your favor. The writ of possession will be forwarded to the sheriff's office. They'll lock out, they'll change the locks with the help of a locksmith. They will physically remove the tenant if necessary. But up until then, you don't take any action, and you never throw the tenant out. You never throw the tenant's stuff out. You never lock the tenant out. Basically, the shortcut for your understanding as a landlord is that you are never doing this yourself. Whether you win or lose at trial doesn't matter. Only the sheriff does this. So save yourself from the time and the very high legal expense of doing this wrong. If you can hire a lawyer, do so, but that's not why I'm here today, to just tell you to go hire a lawyer and then I can go off to lunch. So what should you do as a landlord to do this properly? Well, there's a few things. And we've talked about not using self-help. So that's one thing you shouldn't do. And that'll get you in serious trouble. But one of the first considerations is if you are evicting because the tenant was in breach, meaning the tenant violated a provision of the lease agreement, for example, then you need to determine whether the tenant's breach is curable, meaning it can be fixed by the tenant, or it's incurable, meaning that the landlord, you in most cases, but this is a presentation for tenants also, that the landlord does not have to allow the tenant to cure the problem. And that could be committing, a major offense on the property, for example, that is more than just, hey, knock it off. That's like a once and done kind of thing. So there also could be reasons that, the tenant breached by committing waste, did an improper improvement. If you can allow the tenant to fix that, that would be a curable breach. So if this is something that the tenant has done and it can be fixed, then that's a curable breach, and you should give the tenant a reasonable opportunity to cure the breach. If it's something that cannot be cured, and that generally is kind of clear cut, but talk to your lawyer if you can, or at least look at your lease and see if there's any express provisions. And there's some things that don't even need to be in a lease because they're just so egregious that you need them out. Also, have they been late on rent? Well, that's not an incurable breach. That's a curable breach. If they're late on rent, they need to become current on rent. And the way to do that is to pay the late fee if there is one, and the back rent. Now, sometimes the tenant has not paid the rent, they've not paid the late fee. That's when you can proceed with the 3-day notice to pay or quit. So the example of a curable breach means you give them a 3-day notice to cure or quit, which means the breach is curable. You give them 3 days to fix that problem, whatever they're doing. If they have an illegal pet, if they have an illegal car, but sometimes, it's so egregious. Maybe it's more than just the pet has to be removed. The whole carpet needs to be redone. They committed so much damage to the property that maybe it's not a curable breach because just moving the pet won't be sufficient. Maybe, replacing the carpets might be sufficient, but it's going to really disrupt the tenant's occupancy. So you really need to get them out because the tenant was so negligent. So before you commence several types of unlawful detainers, such as, a 30 or 60-day notice, you need to determine whether the tenant's unit is subject to the Tenant Protection Act of 2019, also known under its legislative title of AB 1482. So AB 1482 gives the tenants a lot of protections, and it also affects what kind of notice you can give. It affects how the unlawful detainer will proceed. and you might actually have to provide relocation assistance in some cases. So we'll get into that in a little bit more detail in a moment. But for now, just understand that the California Tenant Protection Act of 2019, aka AB 1482, is one of the first considerations you need to make. And if you aren't sure whether your property falls under AB 1482, well, if it's a multifamily property that you own, such as an apartment complex, then it probably does fall under AB 1482. It might not fall under AB 1482 if it's located as a single family home and you previously gave the tenant notice of AB 1482 exemptions. So that specific exemption form was given to the tenant by you, notifying them that they are not covered under AB 1482. But if you didn't do that, the presumption is that property is covered under AB 1482. So all those protections do apply to your tenant, even though your property might be a single family dwelling, it might be a duplex, and it otherwise might be exempt from AB 1482. It wouldn't be if you didn't provide that notice of exemption. So after you've made the AB 1482 determination, you'll need to determine what type of notice to send. So the most common categories of specific notice forms are, well, I'm going to show you in a moment, but the most common ones are, 3-day notice to quit, 3-day notice to cure or quit. You might have a 30-day notice for most cases now, especially if it's, the end of a tenancy that was under a year, like month to month. But things have changed a lot over the last 2 or 3 years after COVID. And the notices changed. There are some notices that required 15 days instead of 3 days. Most of those are back to 3 days, but not always. So don't just jump into this. And this is why this is general information, not specific to you, because I don't know where your property is. I don't know what type of property you have. I don't know how long the tenants have been there. I don't know when the certificate of occupancy was issued. These are all considerations that need to be determined because they have important implications. All right, so for example, if the debt arose between September 1st, 2020 and September 30th, 2021, then that would give the tenant a 15-day notice instead of a 3-day notice if they weren't paying. And then you also have to give them certain additional notices depending on what time the breach happened, what time of the year the breach happened, especially over the last 3 years. Okay, the laws changed, and I'm not going to go into that right now. It'll just confuse everybody. Just understand that you need to know when the tenant didn't pay. You need to know if there are any moratoria on evictions or rental increases. If you increase the rent and the tenant didn't pay, that makes it a little more complicated. So we're talking about basic notices here. And you also need to understand that if it's Section 8, like subsidized housing, there's different notices, different time frames. It is more complicated. And like I talked about before, the 3-day notice to cure or quit, that could be also known as a 3-day notice to perform covenants or quit. So if you're a tenant reading this or watching this and you get one of those notices, that's essentially the same thing as a 3-day notice to cure or quit. And that's based on 3 court days, not calendar days. So if you get that notice on a Friday, you wouldn't start counting Saturday or Sunday. You'd start counting Monday. Monday would be the first day. And then Tuesday would be the second day. Wednesday would be the third day. And then after that, the landlord can move for the rest of the unlawful detainer process and start the eviction procedure. But if that Monday instead is a holiday, so you would skip that. So you'd skip Saturday, Sunday, Monday, and then the first day of that 3-day notice would actually be on Tuesday. So let's talk about giving notice. So step 2 would be to give notice. This must be in writing, and you need to give the notice to the tenant of why you will be terminating the tenancy. Now, because the notice you'll be given at this stage is not yet a court document, you can serve the notice directly yourself as a landlord. Or you can always have a friend or professional do it, which is a better idea to have a third party who's less interested, less biased, presumably, than you are, the landlord. Just make sure that person is at least 18 years old or older and mentally competent. So you have 3 options for service. Personal service would be option A. That's usually the best. You should try to give the notice to the tenant in person first. But oftentimes, even though you know the tenant lives there, and maybe you even know the tenant is at home, the tenant knows what's coming. They know they didn't pay the rent. They know they're in violation. They know that you're going to serve them with a notice, and they think that maybe if they don't answer the door, they'll get extra time. Well, you have to make a reasonable attempt. Try to make 2 or 3 reasonable attempts to serve them in person if you can. And if you can't, then go to option B, which would be substitute service. So in substituted service, this is when you cannot locate the tenant at the tenant's home or unit. So if that's the case, you can leave the copy of the notice with another person at the tenant's home or the tenant's work who is at least 18 years old and, as I said, competent. So if the person's mentally disabled, if they can't make legal decisions themselves, they have some kind of guardian or conservatorship, whatever, then that is not going to be valid. Leave it with somebody else. So you can choose between their house or their workplace. And then option C, you've tried option A, you've tried personal service, you've tried option B, you've tried substituted service. Option C would give you the post and mail option. In this case, you'd post a copy of the notice in a conspicuous location on their door, for example, and then you mail the copy to them. So option A is preferred, but if you have to use option C, you must mail a copy of the notice to the tenant, like I just said. And it doesn't really matter whether you use like first class or certified. If you use certified, they might not even accept it, so it might be kind of pointless. So first class mail is usually pretty good. I don't believe that certified mail really provides that much assurance, because you could send a blank envelope. You could send an envelope with a blank piece of paper in it and say that, look, on this day I served them. Look, there's proof of delivery. But how do you prove what was actually in the envelope? All right. So lastly, make sure that you or whoever serves the tenant with a proof of service. In other words, there's a form that will be filled out by the person who delivered that notice to the tenant. That's called the proof of service. That shows the court proof that you served the tenant with the proper notification. So the person who does that, whether it's you at this stage, or start to get in the habit early now, even though you don't have to yet, you should use somebody else to serve these papers. And that person must fill out the proof of service and keep it, and then give it to you, the landlord. Don't give it to the tenant, and make sure that that person doesn't keep it themselves. Get the original, keep it. So if the notice was not, or if the notice was handed to the tenant, that's ideal. But if not handed to the tenant, then the date the notice was handed to a substitute at the tenant's work or home, plus the date the notice was mailed, is how you would count the days of service. So you get extra time. In other words, the tenant gets extra time for service, to respond to service, if you didn't serve them in person. So that's one of the downsides of using option B or C, substituted or post mail. And then make sure whoever served the notice completes the copy, and that notice, that proof of service that the person who served completes, has the language, "I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct." So there are requirements for that proof of service. Make sure you follow them. You don't want to get your case dismissed on a procedural matter for just some ticky-tack violation when you have a perfectly legitimate basis to bring your suit. All right, so step 3, wait to see if the tenant responds. And then if the tenant complies within the notice deadline, great. If not, then you get to move to the next step. So the duration of the notice deadline depends on the type of notice that was served. And in general, we're counting court days, not calendar days. So for example, with a 3-day notice to perform covenants or quit, also known as a 3-day notice to cure or quit, this gives the tenant 3 court days to perform. So this means you don't count weekends or holidays. So if you gave the tenant notice on Wednesday, you gave them this 3-day notice to perform covenants or quit, whether you gave it to them or your person that served them did, you wouldn't count the first day. You wait until the next day, and that's day 1. So that's Thursday, right? You served them on Wednesday. Next day is Thursday. You start counting Thursday. Friday, you count. That's a good day. Saturday, no, not a good day. That's a court weekend. Sunday, no, not a good day. It's a court weekend. Monday, no, not a good day. That's court holiday. So if Tuesday is the good day, that's the day that you get to count as day 3. And then day 4, that's a good day too. That's Wednesday. That's when you can actually initiate your suit in court. All right. So you see how a 3-day notice would actually give the tenant 1, 2, 3, 4, 5, 6, 6 days before you, the landlord, take action on the next steps. Because to be very clear, in case this wasn't clear, you're not counting any court holidays or any court weekends. And the courts sometimes follow holidays that the rest of the state doesn't. So be mindful of that. You don't want to get these things thrown out. These aren't just gotchas. These are to give the tenant, whoever you're trying to evict, proper time to address the issue, and also to seek help from the court. Because if the court is closed on the weekend and the tenant needs to get legal help, such as from the small claims advisor or civil clerk advisor, etc., civil clerk department, it's only fair that they have working court hours to do so. All right, so if you're requesting rent during one of the COVID-19 protected periods, such as through a 15-day notice to pay or quit, then you must have given your tenant a blank financial distress declaration form for your tenant to complete and return at their discretion. That's not based on the tenant's request. That's based on your statutory obligation as a landlord. You have to give it to them whether they've requested it or not. Now, if your tenant did or does this, then additional steps will be required before you can proceed. In other words, if the tenant does fill out and return to you that blank financial distress declaration and has a legitimate basis for doing so, which is not to be determined by you, just the only thing that is your prerogative is to give them that blank financial distress declaration and wait to see if they fill it out. And if they do, then you probably cannot proceed with the eviction. If that was an eviction for during one of those protected COVID periods. If it's an eviction now in many areas of California, but not all, you can proceed. You don't have to give them that blank financial distress declaration because most of the protected periods have expired, but not all of them. All right, so be careful. Next, start the unlawful detainer. So we're getting to step 4 now. And after you've waited the number of days that are required for the notice to expire and given your tenant an opportunity to cure if the breach was curable, only then can you proceed with the unlawful detainer. But before you go to the courthouse, you'll want to have the following ready and in front of you. First, the original lease or rental agreement. And be sure to include any addenda or changes that you and the tenant agreed to. The original, number 2 now, or a copy of the notice that was served on the tenant, which comprises the basis for this unlawful detainer. 3, the original or a copy of the proof of service of that notice on your tenant. 4, and while you don't necessarily need it at this step, if you have any associated agreements, photos, receipts, etc., that are relevant, it'd be a good idea to locate those now. So for the official court summons, complaints, and cover sheets, you will need the following. Now, this is really important. This is the form SUM 130. This is the unlawful detainer summons. Next, you'll want the unlawful detainer complaint. This is a form UD 100. Next, you want the plaintiff's mandatory cover sheet and allegations form. That's UD 101. And lastly, you want the civil case cover sheet, which is CM 010. Now, I'm going to provide you QR codes that hopefully you will find helpful. This allows you to just scan the screen with your phone, and it should bring up that respective court form. So try it. I'll leave this up for a sec so you can use your QR code scanner on the screen, and that'll help you identify those forms directly. Now, that's probably on your camera, on your cell phone. You're going to need to print these, but that's how you can access the form, and then you can email them to yourself, or if you're on your home Wi-Fi network, you can print from your phone if you have your printer on the Wi-Fi network. Okay, so hopefully this helps you locate those forms a lot quicker. And if anybody asks, I'll put the links in the description if you have trouble finding them. All right, so step 5, complete the court forms. Now, when completing the forms, you need to enter the address of the Superior Court in the county where the rental property resides. Okay, so this is based on the physical location of the property that the tenant is renting, not the landlord's address if it's different. It's the property itself that you're leasing or renting out to the tenant. And you'll also need to enter the specific courthouse that handles unlawful detainer cases in that jurisdiction, right? So there's 2 considerations here. There's jurisdiction, there's venue. So you don't just go with the only or the one of the courts in that county. It's more specific than that. It's the specific court in that county that hears unlawful detainer cases, right? So there might be, like in San Diego, there's multiple courts. There's Corona Mesa, there's downtown, there's North County, but not all of them will hear unlawful detainer cases. So they're all within San Diego County. It's just the one downtown will usually be the one hearing unlawful detainer cases. So if there are multiple people living at the property, you have to list their names, even if they're not on the lease. So those would be unnamed defendants. And the filing fee you'll need to pay depends on the amount of money you are demanding. And this fee could approach $500, but that fee for some people is too much. They can't afford it. Even if they're a landlord, not all landlords are wealthy. Some landlords earn less than their tenants, a lot of retirees, etc. So don't just assume that because they own the property that they also have the financial resources to prosecute these cases. You can apply for a fee waiver. If you're the landlord filing for an unlawful detainer, you can apply for a fee waiver. If you are a tenant needing to file an answer, you might be able to apply for a fee waiver too. Talk to the court clerk. And then go to the court's website and find out if there are any local rules specific to that courthouse. In other words, San Diego County has several courthouses. They don't necessarily all follow the same rules. Usually they do for the most part, but there might be rules specific to that courthouse. For example, how they meet. Maybe they only meet virtually. Maybe they only meet in person. Maybe they only use Teams. Maybe they only use Zoom. Find out the local rules for that court in advance. If you're thinking about it now and you've already been served, do it now. Don't wait till your case or wait till tomorrow. Don't put off till tomorrow what you can do today. So go to the court's website, find out if there's any rules that are local to that specific courthouse. And if there are, you may have to fill out additional forms and obviously comply with additional steps unique to that courthouse. Next, make at least 2 copies of all the court forms and your docs and records, and give the original to the court, keep 1 copy for yourself, and then give 1 copy to every defendant you serve. After you file with the court and get the court stamped copies on all your court documents, you'll need to serve the tenants. And the tenants will be the defendants in this case. You must have someone other than you serve the defendants with court papers now. All right, now these are legal court documents. It has to be someone other than you. You can use a professional process server. You can use a friend who's over 18, who's competent, who agrees to fill out that proof of service and give you back the original. Step 6, wait for the tenant to respond. So after having the tenants served, then your tenant has 5 court days, remember, to file a response with the court if they were served in person. If they were not served in person, then they have an additional 15 days to file a response. That's what I was talking about earlier. Hopefully that was clear. If not, hopefully it is now. So if the tenant doesn't respond by the end of this notice period, in other words, 5 days if you serve them in person, or 15 days if they were not served in person, such as the post and mail approach or the substitute service. But either way, if the tenant doesn't respond by the end of those notice periods, either 5 days or 15 days, then on the day after the notice period ends, you can file the forms asking the court for a default judgment, meaning you should win by default because the tenant didn't even respond. Now, even if the tenant files a response after the notice period is expired, you can still work with the tenant directly or via a mediator to get a resolution in addition to or in lieu of going to court. So think about whether it's better for you to work out a settlement, a mediation now, because then you'll have absolute certainty of what the outcome is because you've agreed to it, versus leaving it up to chance, to fate, and to a judge's discretion, which could be highly subjective. These are just people. Now, step 7, if the tenant responds, ask for a trial date if the answer is filed. And the tenant might file a demurrer or a motion to quash. So there's different avenues for the tenant to go, and you have to understand how to respond to each one. So if the tenant doesn't respond within 5 court days, you can petition the court for default judgment. But what if the tenant does respond? Well, in that case, you can ask the court for a trial date, and you'll go to trial. You can even ask for a jury trial. But the point is, you both deserve your due process. You both need your time in court, even though each one thinks there's no point, you should just win. That's not how it works. All right. So if the tenant files a demurrer, then this means the tenant's alleging that the complaint failed to include all facts or legal requirements that justify an eviction. And if the tenant's demurrer is successful, then the landlord may have to start the case and the service all over again. Not that bad, but still a pain. But if the tenant files a motion to quash, then that means the tenant's saying that the landlord failed to have the summons and complaint served properly. And then if the tenant wins, this would obligate the landlord to have the summons and complaint reserved on the tenant. And if the landlord wins, then the tenant will need to file an answer immediately. All right, so one more time so that's clear. If the tenant files a demurrer, that's because the tenant is saying that the complaint just itself didn't include all the facts or legal requirements that justify an eviction. But if they file a motion to quash, that's basically saying you didn't serve properly. The motion to quash is basically the motion to quash service. So, step 8, go to trial. Now, at trial, you want to be as over-prepared as possible without bringing or introducing evidence that is not immediately relevant. So you want to have all of your relevant exhibits organized, tabbed, and with a table of contents. Just go overboard in how organized you can make this thing. More time you spend now means less time the judge has to spend looking for it, which means more time you'll probably have to make your argument rather than just wait for the judge to shuffle the binder to try to find the exhibits that you uploaded or provided in person in court. I would recommend you put all of your exhibits, which includes the photos, which includes the original lease agreement or contract, any addenda, any other written agreements, emails, screenshots of text messages. Put that in a binder with a table of contents and then tabs. So the table of contents will say A, lease agreement, and then the tab is A, and it easily identifies the lease agreement. They can pull it right out. You can also put them in sheet protectors. So the tab, sheet protectors allow the judge to go right to that sheet protector, pull the exhibit out, the physical one if they're in person, if you're submitting physical exhibits, and that makes your life better because it makes the judge's life better. Now, ask any friendly witnesses to accompany you and make sure you ask them well in advance. And then if you or the tenant will require an interpreter, you need to ask for interpreters as early as possible, especially if you have one of those, they call them exotic languages like Turkish. Ask way early, way before the trial date. And now at trial, you'll make your case or testify to the judge. This can be easier if you write down your testimony in advance with all the important facts and details you need the judge to hear in a way that's easy for you to look at while you're talking to the judge. So don't read word for word. Don't read whole paragraphs at a time. Just bullet points with key dates, key figures. That will really help you sound smart. The clerk will deliver you a copy of the judgment in person or in mail, usually through mail. And if the tenant failed to appear at the trial, then give your tenant a copy of the judgment so they know what the judge decided, whether you won or lost. Step 9, after trial. So if you lose at trial, then your tenant gets to stay in the home. But if you win at trial, the judge will sign a form called a judgment of possession. The judge can also order that your tenant pay back rent, damages, court fees, even attorney's fees. So if you win, you'll need to complete the UD 100 judgment of possession form, and that's technically titled Judgment Unlawful Detainer Form UD 110. And you also want to, the form gives you the right to get your home back and to collect money if the judge says your tenant owes you. And it should say exactly what the judge ordered at your trial, right? So you want to use that form and tell the tenant exactly what the judgment was. The judge will sign it before you give it to the tenant, and then you'll file the copy you completed and the judge signed with the court clerk. So make sure you get a copy for your records and make a copy for your tenant if the tenant wasn't at the court date. Then finally, fill out a writ of execution form, also known as EJ 130. This gives the sheriff permission to lock the tenant out of your home. And if the tenant owes you money, it gives the sheriff authority to collect the money. They can do like a till tab. They can garnish the wages, and only the sheriff can do that. So be sure to complete item 25 on page 2 of the writ of execution form, the EJ 130, because this is the part that says you have a judgment from the court, and it is basically saying that you have the right to get your home back. So take your completed EJ 130 writ of execution form to the clerk's office to have the clerk issue the writ of execution. The clerk will just put the court stamp on it, and now it's executed. And then the clerk should automatically send that writ to the sheriff's office, but in case they don't, wait a week and then follow up with the sheriff to see if they've received it and if they need anything from you so they can proceed. And after the sheriff receives the completed and court-stamped writ of execution, the sheriff will give the tenants 5 days to move out before being forcibly removed and authorizing the locks to be changed. And again, only the sheriff can evict the tenant. Don't get eviction confused with unlawful detainer. That's the last stage in unlawful detainer, is the eviction. That's only for the sheriff to do so. And then here's a link for more information from California Court Self-Help. Here's the end of my presentation. I didn't think I could do this in one sitting. So thank you. I hope you found this valuable. I hope you can give me some feedback on how to make these better and more informative. But I enjoy doing this stuff. I know it helps. Well, maybe it doesn't. I know I enjoy doing it, at least. Hopefully it helps. And it's terrible to have to go through one of these. I totally understand how excruciating an unlawful detainer could be. I've done a lot of these for landlords, and I've helped a few tenants defend against them as well. But it's a very emotional experience. It's really trying. And what makes it even worse is the confusion, the anxiety, the uncertainty. So at least control what's within your control. And the way to do that is to learn what your rights are, especially as a tenant, what deadlines you have, what the penalties are if you don't comply, and what options you have. And if there's any way to work this out with your landlord, such as like a cash for keys kind of thing, like, okay, I will move out. You don't have to file an unlawful detainer. Help me out with my moving expenses. And in some cases, they might be obligated to. This is why AB 1482 is really important, because there are at-fault just cause, there are no-fault just cause evictions. These are all things that have to be considered in the context of AB 1482. It was relatively recent legislation, came out in 2019. So that concludes today's presentation. Please be active on the video. Let me know below in the description or the comments if you found it helpful, what you liked, maybe what you didn't, what I can do better, and what topics I should do next. Have as good of a day as you can.